witness chair as I'm doing the intro. All right, welcome everyone to this session of the House Committee on Government Operations and Military Affairs. I appreciate everyone's patience as we were dealing with a little bit of technical issues and we're starting a few minutes late. So we are going to be discussing H649 and act relating to the Vermont Truth and Reconciliation Commission. And before I have Legislative Council start to tee things up for us and give us a little bit of background on open meeting law and the open meeting sections that I think we're going to focus on today, I did want to say that our focus here in government operations is going to be on not the work that was done last biennium on setting up the Truth and Reconciliation Commission, but rather how we are going to deal with some of the issues, both with the procedures for how the commission is going to do its work, and also this issue of filling a vacancy. And I know I've already received some communication, I'm sure other folks on the committee have, where folks would like us to, consider changing the commission and thinking about its scope of work. I think that those are valid conversations and we should be having them, but that is not the work that the Government Operations Committee is going to be focused on. So just wanted to frame that up for all of us and the folks back home, that we have a couple of procedural and technical issues that are really the focus of this particular bill. And with that, I'd like to invite Mr. Anderson to give us a little reminder, a refresher on open meeting law. So thanks for being here, Tucker.
Good afternoon. For the record, Tucker Anderson, Legislative Counsel. Wonderful to be back and to zoom out from the granular world of municipal charters and the broader world of open meeting law. A little bit of an overview and refresher for all of you. So we touched upon this at the beginning of last session, gave a little bit of a primer on the open meeting law and how it applies to the public bodies of the state. So the quick reminder version here is that all public bodies, that means multi-member bodies that make consensus decisions. You might think of them as commissions or committees, task forces, things like that, are subject to the open meeting law requirements of 1 VSA section 310 through 314. Any gathering of a quorum or more of members of that public body requires compliance with the open meeting law and the procedures for meetings in the state. So what is a quorum? By default, it is a majority of the members of that public body. So whenever you have a majority of the members of a public body gathering to discuss the business of the public body, you have a meeting that is subject to the open meeting law. If this hasn't already started to tee up a little bit of a sensation of what the problem is here today, well, here's the spoiler for my fellow sci-fi nerds. This is a 3-body problem. In statute, when you create a public body that has 3 members, it is impossible for the members of that public body to have any discussion of their business without meeting legally under the open meeting law. So this has happened quite a few times in the past, where public bodies are stuck in cones of silence because any communication concerning the business of their public body would trigger open meeting law requirements. Warnings, posting agendas, holding the meeting, recording minutes, and that is for any deliberative discussion of their work. The most recent example, besides this one, would be the tax commission that was formed 2 biennia ago, and that could only have conversations about their work in warned meetings that were held in this room.
Representative Chase.
Clarification, is the quorum of the total number of people that's supposed to be included, or does it include vacancies? Like if you had a 10-person body and 5 vacancies, would a quorum be 5 people or would a quorum be 3 people?
It would be the quorum of the public body as it's established in statute. So it would be a quorum of 10.
Regardless of vacancies.
Correct.
Thank you.
All right.
This is key to not just this particular commission, but many of our boards and commissions and other bodies that that we set up. So I just want everybody to kind of know that this is not unique to the Truth and Reconciliation Commission. Representative Hooper, did you have a question?
Trying to decide, actually. No, not yet. I will.
Quickly touch upon the concept of the business of a public body. It's not necessarily implicated beyond what we've already discussed with the free body problem. Any time in statute that you're assigning a duty to one of these public bodies, it will immediately trigger a meeting requirement for deliberations about that duty. So something to keep in mind for the future when you're determining whether to give a duty to a specific officer of government or to that consensus public body. If you give duty and authority to the body instead of a particular officer, you're going to trigger meeting requirements anytime that function is carried out. Something that articulated in this room in the past about some of the decisions and other bills that you'll be making. Okay, so moving on to some other issues in the open meeting law that you're very familiar with. Quickly remind you the work that you've done around electronic meetings. By default, under the open meeting law in 1 VSA section 312A2, electronic meetings are permitted currently, so long as there is a designated physical location where a member of the public body or staff is present and that complies with Vermont's public accommodation laws. That is suspended until July 1st, 2024, based on the temporary authority that you passed last year and that you also passed in 3 preceding sessions as well. Any questions on electronic meetings? You are all very familiar with this by now.
And we will be revisiting these. I think that the Senate is taking the first crack at a more permanent solution of that in a bill that we'll receive later this session.
In 2022, the General Assembly enacted a bill that codified a new 1 VSA section 312A that provides that temporary authority that you've put in all those bills will automatically be triggered whenever there is a declared state of emergency. All right, I think that's most of the concepts that you need. The only other one that I would touch upon would be executive sessions. 1 VSA section 313. Executive sessions are allowed upon motion and then vote of the public body to enter what is informally known as a closed session, where the public may be excluded and where the public body may deliberate on a specific issue contained in the motion that meets the criteria, one of the criteria, under 1 VSA 313A. There's an enumerated list of the bases for the motion that you're allowed to have a closed meeting. That's all. I think I already mentioned this, but there's no constitutional requirement broadly for open meetings. There's really only one constitutional requirement as far as that's concerned, and it's the open doors provision of the Constitution that governs the State House, that the doors have to be open when the General Assembly is in session, unless there's essentially a public safety or public health concern that would require them to be shut. But as far as the state and its political subdivisions and all of those wonderful public bodies, it is all a creature of statute.
Don't feel the power broadly. All right. Thank you very much, Tucker, for teeing up those broad concepts for us. Like Damien, the SWAT seems to be. Welcome back.
Thank you. Thankfully, Tucker's not going far. So for the record, Damian Leonard, Office of Legislative Counsel. So because we've got Tucker here today, I want to take advantage of his time. And so I want to, instead of walking through the full bill, start with section 8 and look at sections 8, 9, and 10. And then if we have time, I'll go back and do the other sections today. And otherwise, we can do them the next time I'm in. So Section 8 is amending existing law for the Truth and Reconciliation Commission. The first change is on the bottom of page 8. And we're really just adding in a cross-reference here that I'd left out before. So it's saying, notwithstanding any provision of Chapter 5, Subchapter 2 of this title, which is the open meeting law, or Section 911 of this chapter to the contrary, the commission shall permit any individual that they interview to elect to have the interview held in private. So basically, if you're being interviewed by the commission about your experience of discrimination, you can elect to have a private meeting with them so that your name and the video recording are not public forever. And that's something that was in the existing law. We've added in this notwithstanding language to clarify that it's notwithstanding the open meeting law.
So the existing law, Damien, just contradicts or is a deviation from the open meeting law.
It is.
Referencing it, and we're just adding the reference and making it clear that we're notwithstanding.
That's a good way of putting it. Yeah. Yeah. So this is already the existing law in here. And so we're just clarifying that, yes, this is a deviation and we intend to deviate from the open meeting law here. So Section 9 adds a brand new section entitled Commission Meetings, Alternative Procedures and Exceptions to the Open Meeting Law. So notwithstanding the open meeting law, it first, and we're on page 9 here for those of you who are following along, first permits a quorum or more of the commissioners to attend a regular, special, or emergency meeting by electronic or other means without being physically present at the designated meeting location. So this allows the commissioners to attend virtually, and the quorum requirements are not affected because they can have a quorum of virtual people at a meeting. Second, it provides that the commission is not required to designate a physical meeting space. So they could have a virtual meeting with the public here where they just set up a virtual meeting space. And then third, the members and staff of the public body are not required to be physically present at a designated meeting location. And so again, this allows them to have meetings remotely and to have meetings with people who are around the state. So you could have people attending from the Northeast Kingdom, from Brattleboro, Bennington, and they can all meet virtually here. So B provides certain requirements for when the commission does meet electronically in order to ensure that there's public access. Those requirements are listed at the top of page 10. The first is they have to use some sort of technology that permits the public to attend through electronic or other means. The second is they have to allow the public to access the meeting by telephone. The third is they have to video record and live stream the meeting. And the fourth is that they have to post the information that would enable the public to access the meeting and include that information on the published agenda. So just like we do for our meetings here, they're using technology that allows electronic attendance. They're allowing the public to call in. They're video recording and live streaming. And they're posting the information on the agenda so people know where to go.
Representative Hagan.
Thank you. Damien, posting any place physically or not?
Tucker? Sorry.
It depends on what the public body is. Municipal public bodies are required under the open meeting law to post at the town clerk's office and in 2 designated physical locations. Under the suspension temporary authority concerning the open meeting law, it's allowed to be virtual locations. That's not included here. So, because they're not a municipal public body, they're a state public body.
So they don't have to have
They
a
do not have to
physical.
have a physical location.
Thank you.
Thank you, Tucker.
And just for framing, is this largely the same as the temporary authority that we did in Act One last year? Or are there key deviations? It seems at first glance like this authorization for the commission is really modeled on what we did in Act One. Is that?
There's one addition here, and that's the requirement to video record and live stream, which is currently not expected of the temporary authority. So it's verbatim what the temporary authority means, except there's the additional duty, you have to video record it and live stream.
And as it's structured here, this would just run, this authority would run contemporaneous with the authority of the Truth and Reconciliation Commission. So this is basically saying, even if that temporary authority from Act One goes away, these are the rules for the commission.
That is correct.
Yeah.
Okay. Thanks.
Other questions? Okay. So subsection C just below that defines closed meeting as a meeting of the commission that's live streamed and video recorded, but that is otherwise closed for purposes of physical or digital access and participation of the public. So in other words, there's a live stream of what's happening, there's a recording of what's happening, but members of the public can't just jump into the conversation. Similar to what we've done with some of the hearings here where you have to have an invitation to actually join the Zoom call that's participating in the meeting, but anyone from the public can watch the live stream on YouTube. They just can't join into the conversation in the room. And then C2 is another particular piece for the commission here. And I defer to Tucker regarding whether we've used this language before. But what this will do is upon a finding by the commission that there are material threats to the health or safety of the commission, its staff, witnesses, or invitees, the commission may hold a closed meeting. So in other words, a meeting where there's no physical or digital access for the public. And the commission may allow its staff, counsel, and any persons who are subject of the discussion or whose information is needed to access the closed meeting. So in other words, they can have an access controlled meeting if there are threats to the health and safety of either the commission, its staff, or the people participating in the meeting. Mr. Chair.
Yes, sorry, Representative Chase. I had scanning the room, but
So, is that an only situation? Like the rest of the time, if they're doing a digital meeting, anybody has to have access to the Zoom?
So, so for the other digital meeting, they have to permit attendance to the public. They have to allow public access by telephone, similar to what you would do with an open public meeting. At the municipal level, where I assume there's a public question and answer session, if I'm familiar with the meetings from my own municipality here. So I apologize. This is really Tucker's wheelhouse, and it's an area where I go to, only the occasional select board, or I guess city council here in Montpelier meeting. So I'm not very familiar with it. Anyway, and then, so does that answer your question before I move on? So it's essentially they can close the meeting if there's a health or safety threat. Or they can have a virtual meeting if there is no health or safety threat that's open to the public.
Okay.
Does that make sense?
Anecdotally, would that include the possibility of somebody jumping on from out of state with let's say unkind intent, like we saw at the beginning of some of the Zooms that we
Yeah.
hear?
Yes, it would have the potential for someone to jump on the call and Zoom bomb it.
Well, would that include be included in the finding that there are material threats to health or safety would that be a reason to have a closed meeting? Or would that occurrence have to happen first and then?
I think the commission has to make the finding first. Let's see. Yeah, so I think the commission has to make the finding first in order to hold a closed meeting.
C2.
Find, yeah,
That's that.
yes. Thank you. Yeah, I wanted to double check to make sure that there wasn't something that allowed them to close the meeting in process.
Representative Higley has a question if we've resolved that one.
Yes, thank you, Mr. Chair. I apologize for showing up late. Looks like I had to reintroduce my Zoom. I haven't used it in a while, so here I am. But this is kind of a follow-up on Representative Chase's question. What are there specific instances that would warrant a health or safety threat? Who determines that? Is there situations out there in other instances that warrant what a health and safety threat would be?
So the bill would provide that the finding, the commission determines that there's a material threat. I don't know if we have any existing case law or guidance on how to make that determination. But I think that the commissioners can speak a little bit to why the commission asked that this language be included at some point.
I just wanted to, while we're on this, just return and really underscore what the definition of closed is. This is not an executive session, right? We're talking about it being closed to people joining, for instance, Zoom, but it's still being live streamed. People can still be.
Yeah, exactly. So if you think of this, so imagine this meeting if members of the public couldn't just walk through that door. Right now, this is essentially a closed meeting electronically because it's just people who have the secure link that's been set out for the Zoom. And so a general member of the public can't do like what happened at the beginning of COVID, where anyone could just sign on to the Zoom meeting. And so in this case, this is a closed meeting if the public didn't just walk through that door. And that's different from an executive session, where an executive session, no one from the public can view what's happening in the executive session. So, and this is actually actually, if you get down to C3, it specifically addresses that the commission shall not be required to live stream or video record any portion of a closed meeting held in executive session. So it sort of distinguishes the two. So think of open meeting as anyone can come in off the street or from wherever they are in the world if they're coming in electronically and join the meeting. Closed meeting, it's just invited participants. Executive session, public can't view it at all.
And in order to, and I'll give you representations, in order to go into executive session though, on record, make a finding that there's a cause for them to go into executive session.
Exactly.
Just like any other public body.
Yeah.
Okay. Representative Chase.
And if they could have a closed Zoom, but because there's a physical location, that would not count as closed meeting.
That's right.
Like
The public can attend. Right. So the key is open meeting, and Tucker, correct me if I get off track here. Open meeting, there has to be a means for the public to attend the meeting and to join the meeting. Closed meeting, public can view it, but they can't join the meeting. And then executive session is not available for public viewing. It's for a specific purpose. And there is a motion on the record that's voted on to go into executive session. You discuss what you moved the executive session for. When that discussion discussion is finished, you come back into regular session and the public can again view. Some of you have probably experienced this where you'll go into executive session for anywhere from a couple minutes to an hour to discuss a topic, and then you come back and the public is again available. Sometimes there's a decision made that's announced or something like that, or you just move on to the next thing on the meeting agenda.
Representative Hengo.
I just want to make an analogy, and I don't know if this is right, Tucker, but a closed meeting to me sounds a little bit like being on a webinar. You're invited with a specific link, but you don't have dialogue with the folks who are presenting on that webinar. But you're allowed to watch everything that's happening. And that differs from an executive session where you're just, period, not allowed to be in that.
All right, I think we got this. Thank you.
Great, no problem. It's as much of a challenge for me as it is for everyone here. So I had to have Tucker help me through this. So the commission's agenda here has to include information that will allow the public to access the live stream of the meeting. And they also have to post the video recording of the meeting and make it available for inspection and copying under the Public Records Act. So this is again different from that interview we talked about earlier, which specifically excludes these requirements. So an individual who doesn't want their interview with the commission to be public, never available for Public Records Act access. It's a closed meeting. It may be recorded, but it's not available to the public. And then this is an actual meeting of the commission that's open to the public. So there's the open meeting, there's the closed meeting that the public can view either contemporaneously or later. And then there's the executive sessions, which are completely closed. The last piece of this, if you turn to page 11, this addresses the issue of the commission being a 3-member body. And it provides that deliberations of a quorum or more of the members of the commission shall not be subject to the Vermont open meeting law. So in other words, the commission members could finally meet to discuss the business of the commission without having to notice a meeting to meet, whether it's 2 of them or all 3 of them when a 3rd commissioner is appointed.
Representative Hengo.
Thank you. And that's just because this is a 3-person commission. If it were a 5-person commission, this piece would not be.
Yeah, if it were a 5-person commission, you could still add this, but this would not be necessary. Right now, they're stuck where they have to use an intermediary if they're discussing anything besides basic operational.
Has this language been used for other 3-member bodies? No. Okay. We're gonna.
Should it be?
Well, I think that's a big part of why we're having the gravity that's in the room right now about, this as a way to get around this issue, because we do have other very serious quasi-judicial 3-member bodies. So I think about the Public Utility Commission, for instance. And I'm interested as we go through this process to learn a little bit more about how we've gotten around this issue in the past. Let me take Representative Higley and then I'll give you again, Representative Hengo.
Thank you, Damian. If you could go back up to section 9, again, it'd be little a number 1. And I think maybe Tucker explained this. I'm sorry I was late again, but when it talks about a quorum or more of the commissioners may attend a regular. So we're talking 2, correct?
Yeah, so 2 or all 3 of the commissioners could attend a regular, special, or emergency meeting by electronic means. So in other words, they don't have to be in the same room to have a quorum for a meeting.
Okay, thank you.
Yep.
And I wanted to follow up on your statement that that probably would apply if there are any 3-member select boards left in the state of Vermont, correct? Okay.
I'm gonna go to Tucker now, yeah, since we're on this, that's okay.
For this particular provision, I want to note 2 things for you. The first is that deliberations is a very specifically defined term in the open meeting law. And it essentially means the weighing of evidence and the arguments of parties or, similar items that have come before the board. But it expressly excludes the taking of evidence and the arguments of the parties. And the reason it's defined that way, and you just mentioned this, is that the deliberations of quasi-judicial bodies are broadly excluded from the open meeting law. So this is essentially saying that the deliberations of this body, whether or not it's quasi-judicial, are excluded from the open meeting law. They're allowed to have discussions, weighing evidence, talking about the arguments that have been brought before the board, discussing essentially the issues of the body, but not taking action and not coming to conclusions or weighing the evidence. Or what is the term? Taking evidence.
Does everyone feel like they're on solid ground with the distinction between deliberations and the other activities of this commission and other bodies? So this exemption, which can appear really broad, is specifically an exemption that's about the weighing of evidence, not about the collection of evidence, and not about, they can't make any decisions outside of open meeting law.
And that's not unique. Right.
This is not unique for quasi-judicial bodies. This provision being so specific to one public body is unique. There's only one parallel that you could make, and that's the Crime Victim Compensation Board. And to navigate all of the specific issues that come up, for example, dealing with threats to the board, allowing access to people to those meetings who are the people who perpetrated the crimes, and they're there to witness the victims asking for compensation and maybe attempting to intimidate them, things like that. The way the General Assembly navigated trying to give carve-outs to the Crime Victim Compensation Board was to completely exempt that board from the open meeting law.
Just that one particular board.
One other body that I think of, and that's the Community Restorative Justice. I remember if they're councils or boards, but yeah. Those community organizations are exempt from the open as well.
Okay, now, Representative Boyd.
Just a clarifying question, Tucker. Did you say they can or cannot come to a decision?
They cannot, they can't take formal action. This is strictly for deliberation.
Okay, we're all gonna be thinking a lot about what deliberation means. I want everybody to put that in their pocket. This is not the first time, this is not the last time this will come up in this committee this year. All right, let's keep going, Dean. Thank you.
Okay, so that's it for section 9. Which brings us to section 10, another brand new section under the Truth and Reconciliation Commission's Enabling Act. And this would create a new section 912 called Affinity Group Sections, Duty of Confidentiality. And earlier in this bill, we've created express authority for the commissioners to establish affinity groups for individuals who have experienced discrimination as a result of a state law or state program or something like that that they encounter. But the affinity groups are not necessarily run by the commission. They're something the commission can establish, and the commission can talk a little bit more about how they would work. I sort of understand on a basic level, but I think that they can give you a better understanding of how these would work. But the key thing here is this: it's an opportunity for individuals who have experienced some sort of discrimination or hardship to share with other people who have experienced something similar. So obviously some really personal information could come out. The first subsection A, provides that the meetings and sessions of those groups shall be confidential and privileged, and that commission staff and participants shall be subject to a duty of confidentiality and shall keep confidential any information that they learn during those sessions. The next subsection there provides that a person who attended an affinity group session can bring a private action, a civil action in court for damages resulting from a breach of the duty of confidentiality. So in other words, if they are harmed because someone else reveals what they revealed during the affinity group session, but reveals it publicly, they can then seek damages and compensation for that harm. So this is similar to if someone invades your privacy now, you could bring an invasion of privacy action in court. Or if someone slanders you or something like that, you can bring an action for that harm that results from those statements. So this creates an affirmative right of action in statute so that there's a clear tie to what happened in the affinity group. And then subsection C simply provides that this doesn't otherwise limit or affect application of common law duties of confidentiality or any action that could be brought for a breach of that duty. So this is basically saying we're creating an express right of action. We're not intending to limit people's ability to argue that other rights they would normally have may have been breached.
So before I go to Representative Higley, I want to flag, and maybe our fabulous committee assistant can help remind me of this. I don't know that we're the best committee equipped to really evaluate this section. I'd love to have House Judiciary at least do a drive-by if we move this forward and on section 10, because this right of action is probably, we're a little out over our skis, I think, getting too deep in the weeds on this, but.
Right.
Representative Higley, go ahead.
Thank you, Mr. Chair. My comments as well, whether judiciary or somebody else looks at this, I mean, who's the action being brought against? Who's going to represent? Is it they're suing the state of Vermont? They're suing, who are they suing and who's going to represent?
So I'll give you an example. An affinity group is set up. Person A discloses something private during the affinity group session. Person B, after the affinity group session, decides for whatever reason that they're going to publish this information. They put it on Facebook. They put it in a magazine article, whatever it is. By publishing that information, person A, who shared their story and has now had it splashed out in public, experiences harm. They might, could be something like the loss of a job. It could be other financial harm, reputational harm within their community. Now they've been outed as something that was a deeply private family experience, and it's been outed in the community. It affects their ability. Person A, who shared the information and has now been harmed because it was publicly disclosed outside the affinity group, can sue person B, because person B is the person who committed that harm against them. This is the same as if you have two people and there is privileged information, and then the person who receives that information without getting permission shares it publicly and invades the privacy of the person who shared that information with them that was protected by the privilege. So right now it's The same thing as that, where it's the person who disclosed it is subject to a potential lawsuit. And the person who is harmed by the disclosure, who shared the information in the first place, can bring a potential lawsuit. So it's not the state of Vermont who's a defendant here. Unless the state is the one who published it.
Yeah, if I could have a follow-up, Damian. So what if it is one of the commissioners that releases that information that wasn't supposed to be released? Would the state represent them, or are they on their own?
So that's a much more involved question, because you're getting into whether the breach occurred in them carrying out their duties as a commissioner, or whether it occurred outside of their duties as a commissioner. So it gets more complicated when you're talking about a state official, whether it's a commissioner or any state official who has access to confidential information breaching that duty. The question is, did the breach occur while they were carrying out their duties as a state official in good faith, or did it occur outside of sort of the scope of their duties as a state official? So it's a little bit different question then. And if it's outside of the scope of their duties as a state official, the Attorney General's office, which would normally represent a state official, may argue that they didn't do this as a state official. They did it as a private individual, and we're not going to defend them. And then there are a whole host of other pieces here that I don't pretend to be the best attorney in the office to answer, things like qualified immunity and so forth for officials carrying out their duties. And so I really don't want to get too deep here, because I think I'm going to end up saying something that's not quite right. But the baseline here is if it was a commissioner or a member of the commission staff that breached the confidentiality, the state would be looking at whether they did it within the scope of their duties and then making a determination at that point. So that's a much more involved question.
Okay, thank you for that, Damian.
Yeah.
And I will say that once we get through the walkthrough, I'm hoping we'll have a little bit of time today, and certainly more time when we pick this back up to talk with the commissioners and general counsel who are here about the context for some of this. So appreciate everybody getting the words on the page, and then we'll do what we usually do and try to build some context around our understanding of it.
So that's sections 8, 9, and 10. Section 11 is the effective date. And sections 1 through 7, I can start running through those. I don't know what your schedule is. I'm sorry, section 11 is an appropriation. Section 12 is the effective date. So I can start back at the beginning and run through as far as we can get, or I can.
Yeah, I think that's a good call.
Okay.
Barring any, I think it'll be pretty self-explanatory. The previous sections are a lot less,
Yes.
in terms of things to weigh, but just wanted to put a bow on this. So does anybody else have any questions right now about sections 8, 9, and 10, open meeting law? We will come back to these. So we're doing our first walkthrough. I just want to make sure there wasn't anything that was super confusing other than anybody. Not seeing hands, so we'll
Okay.
start back up at the top. Thank you.
So if we go back to section 1, this is the sunset for the commission. And what we're doing in this bill is we're pushing out all the dates for the commission by 10 months because the commission got established more slowly than the timeline that was set out in the original bill. And so this is to give them sufficient time to do their work. So instead of ceasing to exist on July 1, 2026, they would cease to exist on May 1, 2027. And you'll see this repeated over the next several pages. Section 2, same thing. The term of each commissioner ends on May 1, 2027 when the commission ceases to exist. Section 3 gets to the issue that was brought up at our first discussion of this, where we created this selection panel to select the commissioners. And then as soon as they'd selected the commissioners, the panel ceased to exist. And now, unfortunately, one of the commissioners has resigned, and so there's an open spot. So this would reconstitute a selection panel that would only be 5 members. Given the timeline, the way it's been drafted in this bill, instead of having appointees select a panel of people who are not appointed by a state official, this is going back to more of a traditional state appointment process. So your selection panel would be the executive director of racial equity or designee, the executive director of the Center for Independent Living or designee, an individual appointed by the speaker, the committee on committees, both of whom shall not be current members of the General Assembly, and then an individual appointed by the Chief Justice of the Supreme Court. So the governor is not listed on here as with an appointment power because the executive director of racial equity is the governor's appointee. So that would be a 5-person panel. You'll notice a lot of strike through on page 3. That's getting rid of the process from before. And then going down to page 4, we're striking out the ability of the selection panel to establish and maintain an office, because we're not paying for an office that they would largely not use, and also to hire temporary staff. Again, because they're not doing a large search for the whole panel, we're limiting them a little bit. The term of the panel members would begin on the date of appointment and would end on the day the commission ceases to exist. So this panel would be permanent. Important things to note: if someone steps down during that time, if they're an appointee, we'll provide later on that the appointing authority will just appoint someone new. And then if it's someone who's serving ex officio, like the executive director of racial equity, where just by virtue of being that person, they're the appointee or they appoint someone. If that person changes, then the position on the panel changes. Does that make sense?
I just want to flag one thing. We found on other boards is a member of the selection panel could be a member of the General Assembly. They just wouldn't be able to be appointed by the House or the Senate. It would be appointed by one of the other 3.
Right. Yes. That is a very good point. Let's see. Going down, the only other changes we've added to the existing language for the panel is that members of the panel who are not otherwise compensated by the state are entitled to per diem and reimbursement of expenses. The understanding being that at the very least, it's likely that at least 1 or 2 of the members will be compensated by the state. So, and then the panel has administrative and legal assistance from the commission staff. So that's why they don't need to hire their own staff. And then a member of the panel that is appointed may be removed by the appropriate appointing authority for incompetence, failure to do their job, malfeasance, or illegal acts. So we're providing some ability here to not be stuck with the selection panel if something happens down the road and one of the members is perhaps not the best fit anymore. And then a vacancy can be filled by the appropriate appointing authority. Section 4 gets us to the selection of commissioners. And this is where we address the current problem on the commission of having a vacancy.
before we get going into section 4, Representative Higley has his hand up.
Oh, I'm sorry, Representative.
No, that's fine. Just going back, I don't know if it would be in that section 3 or not, but I don't see any deadline that the panel has to appoint a new commissioner. Is that purposely left out? What's people's thoughts on that?
So that is left out in this draft, in part because it's not clear when this bill will pass. It does take effect on passage. You could provide within, 60 or 90 days, something like that. But it is left out.
Again, and like you say, we don't have a lot of time for discussion, but I think if we're talking about a time frame and this thing's moving on and we've already extended things 10 months, I would think there would have to be some sort of a time frame for that. If the commissioners can't work with 2, they need 3. There's got to be a timeline for them to get it done. Thank you.
And that change would go right into section 4 there. So we would probably just amend that subsection D, make that change.
Yeah, so I'm seeing a lot of nodding to this, and I think it seems fairly obvious now that Representative Higley's pointed it out. So do we, I guess what I'd like to understand before we settle on a date, so I think what we'll put a pin in for our fabulous drafts people is that we do want to set a time frame. I'd love to hear from commission staff and other folks about what this, because I don't know all the details about the original selection, but how much time they need and what would be a reasonable number to put in there. Representative Chase.
The problem with that would be is if somebody else resigns, then that date is in statute for filling this one position, but then.
We could make it a time frame though, for all vacancies.
Like 60 days or something.
I was gonna suggest that if we're gonna have an end line, let's leave it flexible for when we start the clock.
Yeah, so let's think about this. So we know it's something we'll have to put in a future draft, but I want to get through the bill and just acknowledge that this is something we should try to get in there. Make sure we get it right. Okay. All right. Thank you.
So section 5 creates a brand new section in the enabling law, and this is section 905A. This was requested by the commission. And it's something that if you'll remember back to our first discussion about the bill history, that was actually taken out of the original bill, and that's removal of power for the selection panel. So this would provide that the selection panel may, after notice and an opportunity for a hearing, reprimand or remove the commissioner for incompetence, failure to discharge the commissioner's duties, malfeasance, illegal acts, or other actions that the panel determines would substantially and materially harm the credibility of the commission or its ability to carry out its work. So this essentially, again, gets to the issue of if at some point between now and 2027, something unforeseen happens that would tarnish the credibility of the commission or prevent it from being able to actually do its work, the selection panel could have a hearing and move to remove a commissioner for one of these reasons only. So they have to make a finding that the commissioner engaged in activity that was either malfeasance, illegal activity, showed incompetence or a failure to discharge their duties under the law, or was some other act that would substantially and materially harm the commission's credibility or its ability to carry out its work. So it's similar to removal language that we have for some of our other boards where there's a specific term and then we provide for removal only for certain causes.
Representative.
So who would decide, who would make that finding? The remaining two commissioners that aren't in question?
The selection panel.
The selection panel.
Yep. So it goes back to that panel of 5.
Oh, sorry,
So-
is that right there?
So it goes back to that panel of 5 who would then appoint her replacement.
And so if I understand it, Damien, the panel exists kind of out there, but only when called upon to fill a vacancy or deal with an issue, the commissioners, that they would come together and meet, but they're not meeting regularly unless one of these duties present themselves.
That's great. Other questions on that section?
Just a quick one, thank you. So the selection panel, does that have to be a majority of the selection panel? Is that specified anywhere?
It is not it is actually specified here. Sorry, I was going to say it's specified in the previous section, but it's actually specified in line 11 on page 6. Reprimand or removal shall only be authorized by a majority vote. Okay. So in section 6, we're adding the power for the commission to establish affinity groups in which individuals who've experienced institutional, structural, or systemic discrimination or are members of a population or community that has experienced that may participate for purposes of sharing experiences and providing mutual support. So it's a may. They may do this. They're not required to, but they may do it. In section 7, we're pushing out the report dates by 10 months, just like in the prior section, pushing out the existence of the panel or the commission, I'm sorry. And section 8 brings us back to where we were earlier. And the only other thing to note in here, and this will be something that goes across the hall to appropriations, I assume, is that section 11 includes an appropriation of 1.1 million for FY25, which was the original annual appropriation that was projected in the fiscal note, and which the commission has not received the full funding that was projected in the fiscal note as their need at this point. So again, they can speak to that, but this is asking for full funding for the commission. And otherwise, the bill would take effect on passage. So whenever it gets through the process, they'd be able to start the process of getting that third commissioner on the commission.
And now we've closed the loop on all the language. Representative Beaver.
I think this is a question for you, actually. What exactly is our timeline on this fix?
So obviously, this is a decision for us as a committee, but I tried to give us some background information and get us teed up to thinking about this and getting to work on it, obviously, in the early days of the session, because I don't want us to wait around. It's my intention, if it's the committee agrees with me, to move this through expeditiously.
I would agree with that. The reason I ask is because we're dealing with concepts that are sunsetting, right? And we're also going to create extensions to some of those things. And there's components to this that are certainly permanent. Are we going to impact some of the more permanent stuff?
So this is I'll kind of bounce that over to Damien. So as I see the construction of this bill, it's basically saying we're doing the Truth and Reconciliation Commission the way we passed it last biennium. We've acknowledged that we weren't able to start its duties, so we're pushing it up 10 months. So all the dates, everything just moves up 10 months. So in that sense, we're not really reinventing anything. Right. There are all those changes. So then this, I want to hear from some of the folks about the affinity groups, because that's the one kind of new thing, the new power. And then we're reconstituting the selection panel in order to have some body to help fill the vacancy and deal with this unforeseen issue. And then there's all the open meeting stuff. So those are kind of the buckets.
Right.
Does that, I don't know if that really answers your
Well, it
question.
does, actually. That's a great answer.
Yeah.
I'm curious to know how much digging we're gonna do in that last bucket, which is open meeting law itself. I mean, I'm curious to know when executive session was first established,
Oh, God.
if we're gonna talk about that stuff.
So what I would say is that this is almost like a reverse echo of what we're gonna have to do when we look at all the open meeting and remote meeting authority, which I assume we will do in the context of S55.
Okay.
And I will commit to the committee that if I'm wrong and we do not get a bill on this from the Senate this session, we will all get together and do a committee bill. I know all of my committee is my community is very interested in what is going to happen after July 1st with this temporary open, remote meeting authority, right?
Yeah.
So obviously we're touching on some of the same concepts here, but I don't think we're going to solve all the problems. One of the things that made me feel a little more comfortable was I asked, is this modeled on what we did in Act 1 last year, where we did the temporary extension through this coming July of the remote meeting authority and open meeting law that we had done during COVID? And Tucker basically said, with the addition of the requirements around video reporting, yes, it's basically the same. So that kind of made me feel like we don't need to spend a whole lot of time on that here, because that's already the temporary law for every other body with that, recording requirement being.
So it sounds to me like you're saying, if we don't satisfy my hopes and the committees for dealing with some of that more in-depth policy, we will.
Yeah, and if we kind of get it a little bit wrong in some way that is unforeseen, as if we pass this bill quickly and we don't quite have the remote authority exactly how we want, when we get to doing the permanent adoption of the remote authority, we could try to harmonize everything. And sort of say, truth and rec, here's the rules, go do your work. But then you're going to be subject to whatever the general laws that we pass, unless we're notwithstanding and allowing there to be. So we are going to have to harmonize any remote authority that's out there with whatever we pass in the future. But I think at this point, we just want to get past this particular thing where we set up a commission that now can't do its work because of some of these unforeseen issues. So those are great questions.
Thank you.
Representative Hank.
Thank you. I'm not sure who can answer this question out of anybody who's here, but during this time where we're kind of on pause because there are only 2 commissioners, what's happening with the commissioners' salaries right now? Are they being paid during this time, or?
So I'll happy to let the commission speak for themselves.
Okay.
But my understanding is that their work is ongoing and the commission and its staff are being paid. But that they're just not able to have non-public meetings right now. That's the issue, is that when the 2 commissioners get together, it has to be a public meeting. Or they're something like this where they're attending another body's meeting.
Okay, that's good enough. Thank you.
Representative Higley.
Thank you, Mr. Chair. Yeah, quickly, and maybe it's been said previously, but when did the commissioners actually get started, and when was the resignation of that one commissioner?
And so we started April 1st. Could you identify yourself? Yeah, so my name is Melody Mackin, and I'm one of the commissioners for the TRC. So we started April 1st, and then Patrick, Commissioner Standen, he left, I think his last day was November 2nd, if I remember correctly.
November 3rd.
November 3rd, yeah. So we have continued to do our work, and we have plenty of things to do, and we can do them separately. So and we're still having public meetings. You will see all of that in our report, which will be to you by Friday. So you'll have all of that. So we are still continuing. It isn't that we've stopped, but Commissioner Standen was very important, especially in terms of disability and lenses that we totally need to do this work. And so we may need to hire consultants if we're not able to get somebody quickly. any sense. We have pieces of this work that needs to be rounded out by a third commissioner, and they have to write certain pieces.
Okay, thank you. So again, I couldn't really hear real well, but so April 1st, the commissioners got started. November 3rd, the commissioner who resigned, correct?
Correct.
Thank you.
All right, so I think we've gotten through the words on the page. So I wanted to know if the general counsel, if the commissioners had any either prepared testimony or whether you might be interested in taking a few questions to round out our understanding of how all this is going to work. So I don't know if it would make sense if you all would, whoever would like to testify, I'm willing to defer to you in terms of how you'd like to engage with us and help us understand a little bit. I think in particular, it might be a good place to just talk generally and then get into the affinity groups and where that proposal's coming in, because that's one piece that's new. But welcome, Commissioner, and I know you have your general counsel here, so thank you for joining us. I'll let you introduce yourselves and then we can open it up for some questions.
And we have Mia, the other commissioners here as well. So Mia, do you want to introduce yourself?
Oh, you're muted, Mia.
Sure, yeah. Mia Schultz, I'm a Truth and Reconciliation Commissioner. Joining you from Bennington, knew that there was going to be some weather coming back. So sorry I can't be in person, but it's a 2.5 hour, drive. So, and back, there and back. So just like emphasizing again, why it's so important to have these virtual options. I'm sure you'll be discussing that further as we go forward. Anyway, thanks for having me here.
Thanks for being here.
And just to reiterate, my name is Melody Mackin. I'm the other commissioner, so we're now a commission of two. Mia's in Bennington, I'm in Barrie, and
I'm Michelle Olvera. I'm general legal counsel. And thank you so much for having us. Damien, did you, there you are. Yep. Did a great job. So the things that we were going to testify about, basically we were going to sort of do different pieces of the bill. I certainly don't need to do that anymore. So I'm just happy to take questions. I don't know if Mia or Melody had just a few things to say before we take questions.
I feel like Damien did an excellent job. I was like, oh, well, I don't do this. But there's certainly pieces that we can talk about. So what questions do you all have for us that we can answer?
I think the first general question I have is what the affinity groups are, sort of how that fits into your practice, and just so we understand sort of why the ask of that new power. I'm curious more than anything, but I wanted to know a little bit about the genesis of that language that's in the bill.
Yeah, so we wanted to be mindful of the trauma that people have when they come to talk to us. People have been incredibly generous in sharing with us some of their stories and also their ideas. During public meetings, we've been really privileged to be able to be guided by the public. And we also want to be really sensitive to the fact that it's hard for people and it has hurt them. So part of their process of restoration, I think, may be aided by what really, I think in common talk is just like support groups or group work, right? People that have suffered similar harms. We've heard from folks that, that experience sterilizations or different kinds of discriminations, really harmful, really hurtful things. And if they would like to talk with other people that have experienced like things, then we want to be able to facilitate that for them. We also know, and people have said, I don't want to advertise. This is really maybe embarrassing or maybe just personal for myself and my family. And we don't want that to be advertised. So that was the confidentiality piece of that.
Representative, go ahead.
Thank you. So rather than interviewing individuals on their own, your concept is to create a supportive group setting for folks to share.
No. No, not rather than. And it's by statute. If someone would like to be interviewed and tell us their stories, we do hope that they do. And that would be really helpful to us in terms of formulating how we might fix discrimination in the future statutorily or provide public forums for people to have reconciliation and truth during those forums. But in support of how they move on personally, right? Having experienced that trauma, we've now potentially created more drama by them telling us their stories. That's a separate piece.
Okay, so the affinity groups, if I'm following you, follow their testimony to you where they exposed themselves and potentially brought up more trauma, and the affinity groups are support groups for them who have all gone through this process of testifying to the Truth and Reconciliation.
Right, the purpose, the goal being restoration.
Thank you.
Right.
And let me give you a little, go ahead, Mia.
Oh, go ahead, Melody, go ahead.
Well, I was just gonna give a little bit of context. Because, so we're the Truth and Reconciliation Commission. The second part of that is reconciliation. So what are the tools that you need to be able to help people in a community move forward? Because we're gonna need things like, if we decide to do this, right? How can we best support people? It's not enough, if someone's coming to us to tell their truth, this is why we're still in the building and planning phase and we're working on a strategic plan, because all of these questions have to be lined up before somebody sits in front of us and is telling us these really hurtful things. And we want to make sure we can support them, right? So this is one tool we could have if we decide to do it. And I feel like it could be a very useful reconciliation tool, if that makes sense. If it happens, but yeah. Mia, did you have something?
Yeah, just to build on that, really, part of our work that we've done, publicly is create a mission statement. And part of that mission statement is about uplifting and centering the people who have been harmed and their truths. I mean, that's why we're here. That's why we were formed. And that is also part of the pathway towards our healing and our collective healing together as a state. And as these individuals, decide to tell their truths. And so we want to be able to offer as many options that feel comfortable and safe, quite frankly, for those people. And affinity groups is, one of the many options, as my colleagues have said, towards that mission of healing, quite frankly. And I would also say that, just generally, we want this to be reparative for all of us. And that means giving options in every way possible. And so that's, kind of the thinking of the affinity spaces, just adding an extra layer of safety.
Okay. Thank you. That really helped my understanding of what you're trying to get at, and realizing, and David, I think, did a good job of emphasizing it's a may, right? So it's giving you a power to set things up. Representative Hinckley, go ahead.
Yeah, thank you, Mr. Chair. Thank you, commissioners. I do have a question. I believe the wording initially, in a sense, was any group or individuals that have been adversely affected by Vermont's laws and policies. Again, I think what I'm hearing you say is you're going to accept anybody's testimony that feels that they were adversely affected, but you're not going to make a determination whether or not that was rightly just, right? I mean, and then I guess my second question is, when you were talking about options, what are we talking about there? What options are we talking about?
Well, on the first piece of it, you're asking about whose cases do we deliberate about? And thus far, when we've presented some emblematic cases at our emblematic case meetings, the commissioners vote on whether that is discrimination under the statute, whether they fall into one of those groups or another group that the commissioners want to put into their purview. So that's one. Two, we are not a body where there's hearings on each case to decide who was wrong, like who was the person that committed that wrong, what should happen to them in terms of punishment. That's not what we're about. We're not modeled on that sort of hearing and decision-making type body. I'll let Mia do the other piece of that.
Yeah, we're not, just to emphasize, we're not, the original statute, the original law does not make us a governing body. So we do not get to say for certain whether or not somebody is specifically guilty of a specific course of action, right? But what we do hope is that the state and the people who are attached to the state, right, whether it be yourselves, legislators, or people who work in government agencies, do participate in this process because it's critical to the pathway to restoration. So it's not a matter of blame, it's a matter of moving forward and not ignoring, what's been our harm, the harm that's been done in the hands of the state. So, and that was all determined in our initial legislation. In terms of other, what other options they might have, it would be a one-on-one option. It could be a public forum type of option. It could be the affinity spaces. It can, those are the types of options that we've been exploring for what we're calling testimony right now, or storytelling, right? So again, testimony, some of these language does bring up an idea that this is a governing body, but we're not.
Thank you. And again,
I was going to say the state has many advocacy groups and support groups that will also, give referrals that people might avail themselves of.
Again, that helps me. When you talked about options, I was concerned that it was options for some sort of reparations or whatever at this point, but you're saying the options are for getting their word out to you folks. And I understand that better now. Thank you.
And at the end of all of this, we are submitting a report of recommendations. So whether you take them or not is up to you, or, just in general, the community and pathways to how Vermont can be a place where everybody, because this has to be everybody, right? All people in Vermont should have a stake in a better place, right? And a place where everyone can thrive. So we make our recommendations and we don't have the power afterwards to do anything. It's all up to you. Right? And it's up to people.
Whoever sits in these seats in 2027.
Exactly. So no, we're not making determinations.
Great. Are there other things that after this first walkthrough of the bill that we should be thinking about in particular that you wanted to highlight? Is there anything that we should particularly focus on as we look to go from this draft to something that we can get out of our committee? This will certainly have at least a stop at appropriations if we pass it in anything like the draft form. So it's got other folks that I'm.
Maybe this is a faux pas, but I wanted to ask you all, just there was a mention about the budget, and that is in the proposed legislation about the 1.1 million. That was initially allotted to us in our original legislation, but we did not receive that amount. That basically covers our staff's salaries. We had to get some computers. We had to get set up an office. We have those expenses, but So we're asking for the original amount back that we were initially legislated. That's right.
And Commissioner, if I understand this right, this, as it's written, it's fiscal year 25.
Right.
So, okay.
Yep.
So,
Bless you.
well, that's more of a question for our colleagues across the hall in the appropriations committee. But I think the signal that we would be giving is that from a policy perspective, we support the work of the commission if we pass anything like this draft bill. And of course, would want you to have the resources that you need. I guess my question is, in the current appropriations process, have you, what was the determination that was made? What were you budgeted, if you have that information handy?
Yeah, I did ask, the original was 748,000 is what
Okay.
we were budgeted, where we're given when we started. Or that's what we have now, this year.
Okay, so it's the fiscal year
This fiscal year.
24 that we're in right now.
Yep.
And so the ask for fiscal year 25, which starts July 1st, is the 1.1.
Yes.
Okay. Thanks. Fiscal years, we don't talk about that a ton over in the side of the hall. But thanks for clearing that up, Commissioner. Yeah, we definitely don't want to start to play appropriations committee over here in GovOps. I've tried to keep the firewall as tight as possible. We tell them what we think is important and they figure out how to divvy up the money. Great. Well, we've hit the 2:30 mark.
Yes.
We do have one open slot on our schedule later in this week. And so I'll be conferring with folks offline about when we pick this back up again, but it could be as early as Thursday afternoon, just to set some expectations. But I really appreciate everybody's thoughtful questions on this today. And for all of you being here, and Commissioner Schultz, no apologies if you don't want to make the drive all the way up here. This virtual option works great. Happy to have you that way.
Let me know if you need any more reinforcement on that, right? It's hard living in Bennington, I'll tell you.
So committee,
Thank you very much.
thank you for being here. So we're gonna just take a short break. We will come back on at 2:45. In the spirit of trying to both hear bill introductions from things we didn't get to hear last year and also try to keep some things topically relevant, I've asked Representative Stebbins to present her ideas from H194. So we'll pick that up with a quick just bill introduction because it has to do with some of the areas that we're talking about with government accountability that we're going to hear from at 3. So we'll be back at 2:45.